Deep Dive Podcast by the Boca Raton Tribune.
Welcome to the Deep Dive. Today, we're jumping right into a really significant legal development. There's an emergency request that just hit the Supreme Court, and it touches on some huge themes: identity, passports, official documents, and frankly, the power of the executive branch. This all kicked off Friday, September 19th, just now. So our goal today is to really unpack what's happening. We want to look at the specific legal move, understand the policy history behind it, which is actually quite fascinating, and talk about what's really at stake here.
Yeah, this is definitely one to watch. An emergency filing like this going straight to the Supreme Court, it really puts a spotlight on a very, very contentious issue. How the court responds, even initially, could tell us a lot.
Okay, let's start right there. This emergency request from the Trump administration's Justice Department, what exactly are they asking SCOTUS to do? It's not the usual appeal process, right?
Exactly. It's what's called the application for a stay. They're essentially saying, hey, Supreme Court, we need you to immediately let us enforce our new policy. And that policy would stop transgender, non-binary, and intersex Americans from getting passports that match their gender identity. They want to pause a lower court's order, an injunction that's currently blocking this policy.
So the immediate aim is to get this new rule active now. The rule that says documents must reflect biological sex. What's the administration's official reason for pushing this definition of accuracy? What government interest are they citing?
They're centering their argument on the need for uniformity and reliability in government data. They connect that directly to biological sex, defining it as an objective fact. The filing puts it very bluntly. It says, private citizens cannot force the government to use inaccurate sex designations on identification documents that fail to reflect the person's biological sex. That's the core claim.
Okay, so they see it as an issue of data accuracy for government functions, things like law enforcement, border security.
Precisely. From their perspective, official IDs serve these broader state functions, and allowing self-identified gender markers, especially the X marker, introduces, well, what they call inaccuracy into that system. It deviates from their definition of biological reality.
That really sets up the clash, doesn't it? The government's stated need for this kind of biological data standardization versus, an individual's identity and right to be recognized. But this is where the history becomes crucial, because you mentioned this isn't starting from scratch. It's a reversal of policy. Let's get into that. What exactly are they rolling back?
Right, and that's key context. This isn't just a minor policy update. It's undoing what they specifically call more than 3 decades of State Department practice that was moving in a very different direction until recently.
3 decades. So what did that evolving practice look like? Before the big 2022 change that's now being fought over, how did someone change their gender marker on a passport?
Well, for most of that time, it was possible, but it was heavily medicalized. You couldn't just state your gender. You generally needed pretty extensive medical documentation. Often that meant getting a letter from a doctor confirming you'd had appropriate clinical treatment, which in reality frequently meant surgery or significant medical intervention. So it was tied to medical status, not just identity.
That sounds like a really high bar, and it would exclude a lot of people who maybe couldn't or didn't want to pursue those specific medical routes. How did the 2022 policy change things so dramatically?
The 2022 policy was a major shift. It basically did 2 things. First, it dropped the requirement for medical proof. You could self-select M or F based on your own attestation. That was huge. And second, the really big one you hear about, it introduced the X gender marker, a neutral option. This was vital for non-binary and intersex people who didn't fit the MF binary. It aligned the U.S. with several other countries, moving toward recognizing identity itself.
So just to make sure we're all following, we went from needing proof of surgery or medical treatment to a system allowing self-selection, including M, F, or X. And now the administration wants to rewind all the way back, enforcing a strict biological sex definition, which essentially erases those other options from federal documents.
That's the trajectory. It's a really sharp swing of the policy pendulum in just a few years. And that's why the legal fight against this latest change has been so immediate and intense.
Okay, so who pushed back legally, and what happened when this new policy was challenged in the courts before it got to SCOTUS?
The challenge came quickly from plaintiffs represented by the ACLU. Their argument is straightforward. The policy is unconstitutional, violating equal protection. And so far, the courts have agreed with them. A federal judge down in Boston looked at the policy and issued an injunction, stopping it cold. And the judge's reasoning was strong, found it was arbitrary, not based on sound reason, and significantly rooted in irrational prejudice.
That phrase, irrational prejudice, coming from a judge, that feels like very strong language in a legal ruling. Why is that finding so significant here?
It's incredibly significant. Constitutionally, most government policies just need to pass a rational basis test, basically. Is there any logical connection to a legitimate government goal? When a judge says it's based on irrational prejudice, they're effectively saying the policy fails even that lowest bar. They're suggesting the government's stated reasons, like data uniformity, might just be a pretext for discrimination.
Wow. Okay, so that gives the ACLU's case a lot of weight.
It really does. It signals the court believes there's no legitimate, non-discriminatory reason for the policy.
But the administration didn't stop there. They appealed that ruling, presumably, yet they still ended up asking SCOTUS for emergency help. What happened on appeal?
They did appeal, yes, but they ran into the same wall just earlier this month. The First Circuit Court of Appeals reviewed the case and agreed with the Boston judge. They upheld the injunction, keeping the policy blocked. So you have two federal courts now saying, essentially, no, you can't enforce this policy. It looks unconstitutional. That's why the administration is now making this emergency plea directly to the Supreme Court. They're trying to leapfrog those consistent lower court defeats.
It really highlights the legal strategy involved. So looking at the ACLU side again, how do they counter the administration's claim about needing accurate biological sex for data and security? What's their core argument beyond just administrative process?
They frame it completely differently. For them, it's about fundamental rights, safety, and basic human dignity. John Davidson, their senior counsel, put it starkly. He called the administration's move an unjustifiable and discriminatory action that restricts the essential rights of transgender, nonbinary, and intersex citizens.
Oh.
The ACLU points to the practical dangers. Passports are essential, right? For travel, sometimes for ID here. Forcing someone to carry a document that misidentifies them, that maybe contradicts their driver's license or how they live their life, that puts them at real risk. Scrutiny at borders, potential harassment, even being denied entry somewhere. So they argue denying recognition on the passport directly translates to denying safety and basic rights, like the ability to travel freely.
Okay, so bringing it back to this immediate Supreme Court decision on the stay. What happens next, depending on whether they grant it or deny it? What are the immediate practical consequences?
It's very concrete. If the Supreme Court grants the stay, lifts the injunction, boom, the administration's biological sex-only policy goes into effect right away while the full case continues. Anyone applying for a passport from that moment on falls under the new restrictive rule. But if SCOTUS denies the stay, then things stay as they are for now. The lower court injunction holds, the 2022 self-attestation policy, MFX, remains in place, and the bigger legal fight over the policy's constitutionality works its way through the normal, slower appeals process.
So huge immediate stakes for individuals needing passports. But zooming out a bit, this emergency appeal feels like it sets the stage for a much larger conflict, doesn't it? What are the broader implications we should be thinking about?
Absolutely.
Yeah.
This case sits at a really critical intersection. Yes, it's about transgender rights, but it's also fundamentally about the power of the executive branch. Can the government just decide, based on its current ideology, how identity is defined on official documents, potentially overriding established practices or even medical consensus? The bigger question here, I think, is how the courts will balance the government's claim for data uniformity against the citizen's right to safe travel, to recognition, and the court's own findings of potential irrational prejudice. Which principle carries more weight?
That really crystallizes the tension. You have the government arguing for data integrity, for accuracy as they define it.
Right.
And on the other side, plaintiffs arguing for fundamental rights, safety, non-discrimination.
Yeah.
It forces the court to weigh those directly against each other.
Exactly. It boils down to, what is the primary purpose of a passport in this context? Is it mainly a tool for the state's data system and international classification? Or is its primary role to ensure the safe passage and constitutional recognition of the individual citizen holding it? How the Supreme Court answers this emergency request will give us the first real clue about how they might ultimately decide that fundamental balance.
A really important question, and something for all of us to watch closely. Thank you for breaking that all down for us today.
Glad to be here. It's certainly a developing situation.